This video is a project of the Annenberg Foundation Trust at Sunnylands.
What are some of the different approaches the Supreme Court justices use to interpret the Constitution, and what are the advantages and disadvantages of each?
If you're asking about fundamental method of interpretation, I think you're asking about the major division, not just between the justices on the court, but in American jurisprudence generally. That is, there are those who think that the Constitution is to be interpreted in such a way as to keep it up to date. That is to say, it does not mean today what it meant when it was adopted. Some of its provisions change in order to keep up with the times. My friend Justice Breyer has that view. The other view, which is held by people who are called originalists, and I'm one of them, is that the Constitution doesn't change. If you want to change it, there is an amendment provision. Amend it. It's not up to the Supreme Court to write a new Constitution by deciding that things that never were there all of a sudden are there. I'm putting it rather tendentiously, I think, but those are the two basic approaches: the evolutionary approach, or the approach that, look, in 1791. What is 1791? Why is that a significant date for the Constitution?
I believe in 1791 the Bill of Rights was created.
Right on the nose.
Thank you.
Anyway, as I started to say, an originalist would say, look, when the Eighth Amendment was adopted in 1791, the Eighth Amendment prohibits cruel and unusual punishments. The death penalty was not a cruel and unusual punishment. There's no doubt that it wasn't. The death penalty was the penalty for every felony. It was the definition of a felony, of crime punishable by death. So, it's easy for me to say the death penalty may be a very bad idea. The people don't have to have it. If they don't like it, they can abolish it. But don't come to me and say that the Constitution doesn't permit it, because in 1791, when the people voted to prohibit cruel and unusual punishments, they didn't. This is not what they were talking about. Okay, that's an originalist approach. I take no view on whether the death penalty is a good idea or a bad idea. But if the people don't want it, they're fully able to abolish it by legislation.
It's not quite that people who are perhaps don't hold this originalist view say the meaning of the Constitution changes. I think there is a large area of agreement. For example, it says 2 senators. Now, I don't care how desirable it is to have 6 or to have none. 2 means 2. It meant 2 in the year minus 1500. It'll mean 2 in the year 10,000. But I think Justice Scalia will also agree that words in the Commerce Clause, for example, which says that Congress has the power to regulate interstate and foreign commerce, or words of the First Amendment, Congress shall pass no law abridging the freedom of speech. What is the freedom of speech? What is interstate commerce? There were no automobiles in 1781, 81, 91, 89, 87. You pick your year. There were no automobiles at that time.
89 for the Commerce Clause.
Right. And they didn't even have internet. They didn't even have television. So I think probably we'd both agree that even though there was no such thing in 1789, 91, whatever year you want there, still this phrase applies. The world has changed. Now, here's the area of disagreement.
Okay. Wait. Before you go on. That's not really giving the words a new meaning. It's just saying that new phenomena have come into being which are embraced within the former meaning. It's quite something different, however, to say that the death penalty, which did exist then, the people knew what it was, and the people did not vote to abolish it when they adopted the Eighth Amendment. It's quite something different to say it is now covered by the Eighth Amendment. It's not a new phenomenon. Anyway, go on.
No, but that's quite, now we're getting to a part which is actually rather difficult. Because I will probably think to myself, whether I say it or not, in many of these cases, I will think, well, how do I know the way in which the First Amendment applies to cable television? For example, to take a real case from many years ago, when Congress passed a law that said that cable television owners must devote some of their space to carrying over-the-air broadcasters, even though they don't want to. How does that fall within the First Amendment? So when I get into these real cases, I probably will say what's key is there was a value, there was an objective, phrased in quite general terms, that existed in 1789 and 91 and exists in unchanged form today. The value, the basic purpose, the objective. And then I will look to see how that applies. So to go to a real case where, in fact, the court held that that cruel and unusual punishment clause forbids the execution of those who commit a serious crime of murder, for example, under the age of 18, we said they couldn't be executed. It was not the fact that in 1791, probably there were executions of 17-year-olds. I'm sure there were. But the value that underlies the cruel and unusual punishment clause. Is it cruel? Is it unusual? Those things look around today to see how society today works out what is cruel, what is unusual. And society there may have changed. It's not the values that's changed. It is the nature of society that's changed. And the fact
you picked a bad case because, in fact,
bad for who? For you or for me?
For you, of course.
Well, otherwise, you wouldn't bring it up.
I wouldn't have brought it up.
Right. That's true. That's right.
The majority of the states that have the death penalty permitted it for someone who committed the crime when he was under 18, but it didn't make any difference to the court. The court, being an evolutionist court, just said, we think that you shouldn't be able to execute anybody who was under the age of 18. Now, again, I take no position on the merits of it. Maybe you shouldn't be able to, but the people are able to pass their own laws and abolish it, and it doesn't seem to me it ought to be up to 5 out of 9 lawyers on this court to say, coast to coast, you can't execute anybody who committed a crime when he was under 18. The people never voted for that limitation upon democracy. And that's what happens whenever you impose a constitutional limitation, mostly from the Bill of Rights. What always happens is you are imposing a limitation on democracy. You are telling the people you can't do what you want to do. And my position is, unless the people themselves voted that limitation upon democracy, it's up to them.